CargoWise Landside is deeply committed to revolutionizing landside logistics. With a complete enterprise system built for modern trucking and container drayage operators that includes proven drayage transportation management, digital rate and quote management, real-time container track and tracing, and on-demand truck, trailer, and container storage. Excellence in container drayage starts with the right software. Enhance transportation management, optimize shipment execution, and improve intermodal business operations with Trinium TMS, Draymaster, GeoStamp Track, and SecureSpace. To learn more, please visit cargowise.com/landside.
Hello, everyone. Welcome to LogTech Live. It's the November 1st edition. We are already in November. I can't believe 24 is almost over. It's what happened to this year. It's been a crazy year. So let me first start off by saying happy Diwali to everyone. Happy belated Halloween. They were both yesterday, which was kind of insane. I'm a little rough around the edges this morning, if I can be honest with you, because we had Halloween. We had a full Halloween celebration followed by a full Diwali celebration, which is a lot at my advanced age. So you're going to have to bear with me. My voice is a little gone. I didn't win any money. We usually play a card game. Families during Diwali play a card game, sort of like a little poker game. And I did not do very well. I lost a little bit of money. So, but it's all in the name of fun and spending time with family. And so, in any case, delighted you can all join us today. First-time viewers, you have a fantastic episode you've turned into, especially if you're interested in the legal side of the world of shipping. If you attended the show before, delighted to have you back. We have a fantastic guest for you today who I'll talk to you about in just a little bit. First of all, I'd love to hear where you are all tuning in from. I sometimes forget that this show has a really diverse audience from a geographical perspective. So make sure you drop in the comments where you're tuning in from. And also feel free to tell me anything you want to hear about on this show or in future episodes. If there's certain topics you want to hear me talk more about or have guests that can talk about, drop those in the comments as well. We'll be following them, and I'll make sure that future episodes touch on some of those subjects. But most of all, really just super excited to have you all here. Okay, so a few bits of housekeeping. TPM. If you're planning to come to TPM, now would be an excellent time to register. November 10th, I believe, is the last day of advanced rates, which gives you a discount on a pass for what is undoubtedly the world's biggest and best containerized supply chain conference. So I will be there. Obviously, I'll be leading a whole bunch of TPM tech programming, as well as some other sessions I'll be leading. But most of all, I'm just there to learn and chat with the industry. And anyone who's been to TPM knows it's a can't miss event. So take advantage of those discounted rates while they last. Okay. Break Bulk. That's another event that the Journal of Commerce puts on. It's in April in the Big Easy, New Orleans. We do this every year, looking at the break bulk and project cargo space. Again, I will be there. Once again, kind of touching on how technology is impacting that industry or not impacting that industry. Again, this is your chance to get early bird rates for that event. I believe they end in mid-December. So you have some time, but not that much time. So if you want to get our best rates possible to register for break bulk and join us in April, please do that now. And all of those are in the comments. The links to those registrations are in the comments. Last thing I'll mention, Blended Pledge. I talk about it almost every episode. This is an initiative to make sure that industry conferences are the attendance and people on stage are representative of the industry as a whole. And it's not just a bunch of white dudes with gray hair talking about things. So please donate what you can, whether it's $1, $5, $100, $1 million, whatever you have in your pocket. Give to this initiative so that the industry is well represented on site at events. So again, all of those things are in the comments. You also have to bear with me. I've been struggling all week with a cold, independent of Diwali and Halloween. I've been struggling with a pretty nasty cold. So yeah, I mean, this is the dedication I show. This show had to be done, even though I am struggling in all sorts of ways. But I'm really excited to talk to my guest in a bit. So that's the main reason why I made sure and jumped in today. So news of the week. Let me run through some stories that I've done. By the way, there's a lot of news going on. This week, I focused a little bit more back on the tech side of things. Obviously, there's tons going on with ILA, with potential, a second strike if they aren't able to resolve the contract, which we've talked about. There's all sorts of interesting things happening in various parts of the world, supply chain world. I'm going to focus on some of the things I wrote about this week. I was at the DAT conference, DATCon last week. Fantastic event. Really, really good event. First time I've been. I spoke, but it was really great to meet the DAT team and also meet some of their customers on the brokerage side and shipper side and get some really in-depth conversations. One of the pieces the piece that I did coming out of this event was looking at how automation is, and we're not talking AI, we're talking automation, is having a big impact on the way brokers can think about how many loads their employees can process or manage in a particular day. So this is kind of an easy way to think about the impact of automation. If a broker can do 5 loads a day traditionally, and all of a sudden something can be automated and enables them to do 10 a day, then they're twice as efficient. And you can think about what that means, not only revenue, but also freeing them up or freeing resources in the company up to do different things. So I go into that in detail in this story. It's definitely worth a read. There's some really interesting comments from technology providers and brokers. The next story was from a couple weeks back. Wrote about WaveBL, which is one of the EBL vendors that creates EBLs that shipping lines use to issue electronic bills of lading. I've talked again a lot about this subject. This was an interesting story because they've done a test and again showed that efficiency that's created through using EBLs, aside from all the other purported benefits, is you're just getting faster payments, faster cargo release, according to WaveBL's test of this product. So definitely encourage you to read that story because this is something that's going to keep popping up over time. We have a session at TPM Tech this year where we're going to look at where progress is being made on that on a 2030 mandate, not a mandate, sorry, commitment is the right word. It's a commitment from most of the largest ocean carriers in the world have committed to moving 100% to EBLs by 2030. And so where are we? We're, by the time we meet in March in Long Beach, we will be 5 years away from that. Are we on track? And related to that, one of the people on the session is a guy named Bertrand Chen, who's CEO of GSBN. And the last story I'll pop is a commentary he wrote for us at joc.com about thinking about the electronic bill of lading and this as transformational as the shipping container itself was when Malcolm McLean came up with the idea, or I should say, I don't think he came up with the idea. He implemented the idea. I should actually go back and look at my copy of the box here and get the actual history. But in any case, the idea of this commentary is the electronic bill of lading opens up all sorts of other opportunities. It's not just about digitizing a bill of lading. It's about the things that it creates, the downstream effects of it. So definitely encourage you to read that. Bertrand will be on that panel at TPM Tech talking about EBLs. He's a fantastic thinker about all this stuff. So encourage you to make sure and catch that session if you're on site at TPM. And like I said, register. You have 10 days to take advantage of advanced rates. So do it. What are you waiting for? None of us are getting younger. Okay. So before I bring my guest on, thanks so much to, I saw someone was popping in from Lebanon. Who was that? Nicole, you popped a comment up. Anyway, whoever's joining us from Lebanon, thank you so much for joining. We really appreciate you being here today. But with no further ado, I'm super excited to bring my friend, one of the key legal minds in our industry who I rely upon to help me understand the tons of the maze of legal stuff that's going on around shipping. It's Lauren Beagen, the Maritime professor, also founder of Squall Strategies. Lauren, thank you so much for being here today to talk to me about stuff that I have no professional background in.
Thanks so much for having me, Eric. This is so fun. I'm so glad to join you today.
Yes, this is long overdue. We've talked
It
about this
is.
for a very long time, so I'm really glad we could do this. It seems like the right time too, because there's a ton of legal stuff going on in the container shipping world. So before we get into all that, before we get into what Squall Strategies is and Maritime Professor stuff is, give us your background. How did you get into law? How did you get into maritime?
Yeah, so I'm originally from Michigan, and I actually grew up sailing on the Great Lakes with my dad. And I was just kind of, it started as forced family fun, and then grew to something that I actually liked. And went to Hope College, which is in Michigan, and joined the sailing team, and found that I was kind of skipping my classes to go to sailing. And I was like, maybe there's something here.
Yep.
So I found a law school out in the East Coast, Roger Williams, and they had a joint degree with the University of Rhode Island that was in law and maritime law specifically. So I did that and kind of navigated around. My whole mission has been, as long as I'm in the subject matter of maritime, I'll find the right job, right? So I kind of got the law degree to give me options, but that's how I've been maneuvering my career so far.
Cool. And you had some sort of background with the FMC at some point, correct? The Federal Maritime Commission.
So after I was in Rhode Island, I took actually a contract job down in DC, working at the State Department. So I was working on the Extended Continental Shelf project there for a while. But at the time, it wasn't a position that was for loan forgiveness. And so it wasn't a direct federal job. So then a job opened up over the Federal Maritime Commission, the International Affairs Attorney position, which was a perfect match for me. So fortunate to get that job, and worked over at the FMC during the very pivotal years of about 2012 to about 2017. So right when Hanjin bankruptcy, the alliances that we know today were starting to form.
Right.
So at the time, just a line attorney, didn't know much. It was just taking it all in. But I was also the international affairs attorney, so I was part of the U.S. government delegation for maritime bilaterals, multilaterals, that sort of thing. So I worked at the FMC for a while, and then my then boyfriend, now husband, was always up in the Rhode Island area. And when we were deciding where to go for a family, we decided up here. So I moved up to the Port of Boston, and what a great experience to have that boots on the dock experience paired with the higher level regulatory. So I was actually able to feel the regulated entity side as well as the regulator. So it really gave me this unique perspective. And while I was at Port of Boston, I just missed that national, international conversation that I once had. And during it was the great reshuffle, I guess I'll say, in 2021, and just decided, there's a lot of Zoom happening these days that I think I'm gonna take the jump and start my own company. And so was able to quickly rejoin the national international conversation, and really have found such a passion for working with clients on just different really interesting questions and really pressing matters that they have in front of them.
So, and we're going to be, just for any listener who's tuning in who doesn't know what the FMC is, just a quick background on that, because we're going to be talking a lot about that. So I don't want people to not have the glossary definition.
Yep. That's right. And
yeah, go ahead, Lauren.
Well, and that's I approach it the same way, right? Because if the lawyers are only using acronyms, nobody benefits, right? So the FMC, the Federal Maritime Commission, so they are the independent regulatory agency, missioned with the fair and efficient movement of goods for the U.S. for the benefit of the U.S. importer, exporter, and consumer. I think I can remember that all right for my. But no, they really are the competition authority, whereas MARAD is the promotional authority. So MARAD, the Maritime Administration, that's under Department of Transportation, and then the other side, the sister agency, is FMC, independent. They kind of stay insulated from politics because the highest office, the presidential office, and the administration don't dictate who they get to just install. It has to be confirmed by the Senate, which is not unlike, but they're on 5-year terms. So it doesn't necessarily cycle with the political system. So all that to say, they have that independent nature really does shine through. It isn't like, well, they're independent.
Yeah, it's in my experience, I've 20 years now. It feels very dependent on sort of the personality and the sort of legacy that some of the commissioners want to sort of create over their time. So there's been very laissez-faire Commissions, there's been very active commissions. I would say the one over the last few years has been quite active. But it's, they definitely, the commission has its own sort of independent kind of like strategy is the wrong word, sort of, I don't know, like things that it wants to pursue in the service of what you just described. So
Yes, that's right.
So real quickly before we jump into like deeper, what are you doing now? What is Squall? What is Maritime Professor?
Yeah, so like I said, during the when the Great Reshuffle, I decided that it was time to go out on my own. I am a maritime attorney, right? That I did go to law school, so I started my law company, Squall Strategies, for exactly that reason. I figured that I had some really unique perspectives of having worked both in the regulated entity side, like I said, and also the FMC, and that was when congestion was a problem, if you recall, right? Everybody was buying large sofas and work from home items. And so the detention and demurrage became topics that people not only knew what the words were, but wanted to know more about what they were. So I found myself explaining to a lot of people what detention and demurrage was in kind of very simple, plain language words. And I thought, there's something here. So I started the law company, Squall Strategies. It's more of a consulting. It's almost like pre-litigation. So I help shippers specifically and associations and really anybody in the industry here. I help them navigate global ocean shipping and really what the rules coming out of the FMC are, as it relates to the specific company at issue, how the detention and demurrage might play in. But since there's only so many ocean carriers, specifically in the case of shippers, they don't necessarily want to just go suing everybody, right? But they want to know, are they in the right parameters? Are they kind of in the right world are they understanding this right? So I help them kind of navigate the negotiation from the business to business side. And, we kind of, I help them draft their story, their argument, as they approach it from the business side. Because this is a long-term industry, right? These are relationships that withstand short-term.
You don't want to keep taking people to court or even to the FMC over and over.
Exactly. And
That's
even though
not
they have
traditionally been the way to build relationships with
that's right.
service providers.
That's right. Well, and even even with multi-million-dollar bills here and there, it's still it's a 30-year relationship, and so that even that short-term pain, there's ways of working through that and mitigating that. And there's also you don't have to go straight to, and we're going to talk about this, I think in a little bit, but you don't have to go straight to a formal lawsuit with the FMC either. And so that's part of what I help clients with is how to navigate some of those less aggressive, I guess it sometimes feels, avenues for dispute resolution. But what I was finding was I was having some followers who were like, I really enjoy the education piece, but I don't necessarily need you as a lawyer. Is there any way that you can provide a webinar or some sort of corporate training? So I created a second company called the Maritime Professor. And that's exactly what that's for is, not everything is a law question, but sometimes you just want to hear from somebody who's deep in it, what's going on, and can you break it down, and can we talk about it just generally from different sectors of the industry? So I've provided some webinars, really interesting ones to drayage providers. I had over the road truckers following me on Twitter for a while, so it's been kind of fun learning I'm an ocean side of things person, and I've been bridging my own knowledge gap over into the surface transportation side. And I think that's what a lot of the industry found as well, was they wanted to learn what happened on the other side of the gate, whether they were ocean or surface. So that's been the benefit of the two companies, and it's been really fun.
I think there's been two long term, just in my career, there's been two, the financial crisis and the pandemic were two things that sort of like bumped those two worlds into each other in ways that created that idea that people like, oh, I actually don't understand really what's going on the other side of the fence. So yeah, I've definitely seen that, and I've in a much smaller part, I feel like we've been part of kind of joining those worlds a little bit together too. So okay, we have lots to talk about. What is going on? So we've had a couple episodes where we've dived into the D&D rulemaking and where that is. We did it before it went into effect. We did one after it went into effect in May. Where are we with that right now? it's been, from my eyes, it's seemed a little quiet actually the last 6 months. Is that a good thing? Is it a bad thing?
So I think the industry is kind of seeing what the detention demurrage rules are, how they're kind of integrating themselves in the wild, right? I mean, so May 28th, we had gone through a few different notice and comment periods, which what that means is during the rulemaking process that the FMC undertook, right? They're a federal agency. They pose some ideas out to the industry, saying, "What do you think about this?" And so through that process, they got comments back. They integrated them. They received comments again. They integrated those. They had about 180 comments, kind of each round. So I mean, this was I mean, only 180, but like that is wildly popular of a rulemaking comment period. So the rule came out May 28th, and since then there's actually a petition filed against it, and it was filed right about the right about that effective date time. And what that means is the World Shipping Council filed a petition against the detention demurrage rulemaking, the final rule, saying that there were some things that might have been mission creep or too far jurisdictional creeping. And so now it's over in the U.S. Court of Appeals, DC Circuit. It has been quiet. Now we have to go through the kind of legal process that happens over there. But in the meantime, nothing changes on the implementation of this D&D rule. And so it is the law, right? It is a regulation that was created by the FMC. And I think that it's providing the baseline guardrails that it sought to provide, right? Because I think that sometimes we might be a little unfair in the judgment of this rule because, maybe it's not going far enough, maybe it's not solving all the problems, but I don't think that they wanted to solve all the problems. And really, you probably don't want an agency solving all problems with one fell sweep. So this first rule went from previously it was the Wild Wild West, right? You had a bar napkin that you could put $3,000 on, slide it across the bar, and say, "This is your demurrage bill," and there was nothing that said otherwise. And so now you have this D&D rule that has 20 invoice requirements. So it specifically spells out, date of the invoice, total amount due, rule that the invoice or the demurrage billing is based on, or detention. So it really kind of creates a system where you can check the work of the invoice to try to create better visibility for the industry. And really, I think more of a consistent experience for those who receive the bill, the billed party, so that they know what's going to be coming through in their invoice. This seems so basic, right? Like, how was this not part of it before? But it really was the Wild Wild West that, there was more formality to the invoices, but it was an inconsistent experience for those receiving those invoices.
And just for people who are not clear, it also specified that the shipper had to be the one to receive the invoice, not their service provider. The service provider, we've talked about this on past episodes. The service provider can pay the bill on behalf of the shipper. The shipper has to be the one, the cargo owner has to be the one that is actually receiving invoices for D&D, and that was a key part of the rulemaking. That has also not been without its sort of unintended consequences. But I think, to your point, I remember going to hearings. I want to say like in 2017 that the FMC held around streamlining detention demurrage. Like, this is a long running thing. There is no perfect solution to this. There's just so many different permutations of it. You're never going to create a rule that everybody is happy with. So yeah, again, not making a judgment myself on whether this is effective or not. We just cover it, but I will say that there is no way to sort of rule make out of the complexity of the industry. So,
yeah, and if I can jump in, I've heard both sides, right? I've heard people say this has been fantastic. We appreciate the kind of clarity that comes with the administrative billing, and that's, I think, what they were seeking to do. But then I've also heard that this has been a terrible thing, and that it's actually made it harder. So I think that as any rule integrates into real world, right, the industry, we're going to see how it's impacting. I also believe that we're going to see a review of this by the FMC. I think that the FMC is watching how this is getting implemented, but then also might have perhaps a technical correction round in a few years, a review of how the D&D rule is working. Do they need to go further on a few areas? Do they need to clarify a few areas? Particularly maybe the NVOCC part and the kind of dispute resolution process that happens there, and the 30 30 30.
Yeah,
Yeah, and like there's an additional 30 if the NVOCC is involved. So
right.
that might be something. And then to the direct contractual relationship that you were speaking of, or the consignee, that's really what the petition is pivoting on, is the direct contractual relationship. But then they specifically said that it doesn't include motor carriers. And so what World Shipping Council is saying is that ocean carriers sometimes directly contract with motor carriers. And so what of that situation? So
Right.
we'll see. We're just now starting to get some of the content arguments. We have the petitioners filing at the DC Circuit Court of DC Court of Appeals for the DC Circuit, and then we are waiting on the FMC response there. So we'll see what happens with all of that.
I think audience is starting to get an insight into why I let you tell me about what's going on. It's impossible. It would be impossible for me to keep track of all of this stuff myself, with all the other million things that we cover. So thank you. And definitely encourage you to reach out to Lauren if you want any more detail on this. I wanted to sort of like move back a little bit, because my next question is very much related to D&D, because a lot of cases that have been brought or complaints that have been brought before the FMC over the last few years have been related to D&D, or what might be considered to be unfairly assessed D&D. Where are we in terms of the FMC sort of soliciting almost these types of complaints? Because we saw a lot of activity over the last few years, some of it prompted by the FMC saying, we want to hear from shippers who feel they have been assessed a rate or a fee that they don't feel is correct. And we saw a volume of complaints that we never saw before. Back to what we talked about before. Generally speaking, shippers have been reticent to take carriers in a complaint process to the FMC unless it was some ridiculous amount of money and the relationship was forever spoiled, because you work with these companies, and there's only so many companies that own container ships or run container ships. So in the sake of keeping those relationships stable, you don't tend to take these complaints to the FMC. That changed a bit over the last few years. Where are we right now? Is the volume of those complaints slowing down at all? Is there, give us a lay of the land there.
So we had a new creation that was brought in by Congress with the Ocean Shipping Reform Act of 2022. So we had something called charge complaints created there. And what the purpose of that was to create kind of a quick and dirty version of finding an answer on whether you're right or wrong on, is this charge correctly assessed or not? And actually, at one point, Chairman Dan Maffei of the FMC said that he thought that maybe this was expansive of beyond detention or demurrage, that maybe this was all charges. I think that is something that ultimately, when they push through a rulemaking, we'll see that discussed. As we've seen mostly detention and demurrage on that, because otherwise your option was filing a formal complaint, which can take a few years. And that's part of the hesitation, is because a few years of hiring lawyers is an expensive thing. You also have mediation services at the FMC, but people didn't really know that. Or you can file a report of violation to the Bureau of the Enforcement Investigations and Compliance. It's newly created or newly reshuffled.
CATERS is that the mediation?
Yeah, CATERS is the mediation. So that's Consumer Affairs and Dispute Resolution Services. That's CATERS. And then this BEIC, this Bureau of Enforcement Investigations and Compliance, that's who houses these charge complaints. And so that's kind of what was the creation, but Congress created it, and it was effective upon signing. So June 16th, 2022, when OSRA 22 was signed, charge complaints became effective like that day. You could file a charge complaint without really any guidance on how it happened. So quickly after that, the FMC created this interim guidance. And so you had to provide, the violation of the Shipping Act that you thought that this was violating, your evidence. There's a whole list of things that you had to provide. But through that process, they just reported that there have been either voluntary waivers or refunds of over $3.2 million just from the FMC charge complaints process. I think it was like something like 300 complaints were filed using that service. A normal year for the FMC for a formal complaint, I mean, you're talking like 20 filings, like lawsuits filed, 30 maybe on a really busy year. And the administrative law judge office, which is where it goes first, has had anywhere from they've had as low as one over the past few years to upwards of 3 or 4 ALJs, administrative law judges, handling all the initial review of all those cases. I mean, that's too much, right? I mean, that's an imbalance. And so I think that having other options for the industry to use is a good thing. And so the FMC's also made it very clear, though, the retaliation piece that you were speaking to, that they won't stand for it. And I think that there's a little bit of a misunderstanding, because I don't think everything is bad blood, right? I don't think everything that comes before the FMC, although it's quite an emotional process. I think there's still a lot of really bad, strong feelings from the pandemic and the congestion years there. Some of that was perhaps different interpretations, right? I heard that sometimes demurrage or detention was being assessed because of lost equipment charges that could otherwise, right? There was some interpretation of like how the charges should be best applied.
Yep.
And so the FMC has really kind of come back to this incentive principle. It's for the free and fluid movement of goods and should only be assessed as in a limited capacity, right? That's kind of the feeling that I'm having on the direction that they're moving there. But they also are coming out really strongly saying retaliation will not be tolerated, including if you retaliate against somebody who files a lawsuit at the FMC against you. And that really is getting to that piece of the shippers shouldn't be afraid to file lawsuits. And that's kind of the insinuation, right? Is that they're insinuating that maybe the ocean carriers or the NVOCCs are potentially retaliating against shippers that are trying to find fairness in the system.
So I think this is an interesting legal sort of question. We've obviously seen fairly straightforward, or I would even maybe say blatant cases where there's something in writing that says, if you don't pay us this month, we're not going to move the rest of your containers, or we're going to void your contract, or, there's something that is fairly black and white. Whether whether the FMC can act on it is another question, but it looks very straightforward. There have to be other retaliatory situations where something is unsaid in writing, but through the behavior over a certain period of time, it's clear that, a charge complaint or a failure to pay something resulted in behavior that was retaliatory. How do attorneys and how does the FMC sort of treat that or address that if that's happening? Because I would imagine, most carriers are now smart enough not to put things in writing, even if they have those sorts of inclinations, right? How is the FMC going to address the retaliatory stuff if it's not like black and white?
So they are still, we're still waiting on a third rulemaking that was required under OSRA 22. There's been some talk that it was folded into this unreasonable refusal to deal or negotiate rule. That's the most recent rule that came out of the FMC. I got kind of snowed in during the strike. So it came out September 23rd was the effective date for that rule. So it didn't get the press.
Nice time to release that, right?
Yeah. I know. Well, they released it in July on a 90-day effective date. So it just happened to be right. Yeah. So, but there's a third rule that's the unjust or unfair, just unfairly discriminatory methods that they haven't, they somewhat folded that into the unfair, there's a lot of
the refusal to deal.
Refusal to deal. But they haven't fully addressed it. And Chairman Maffei at one point said that they intend to have a standalone rulemaking on that. It's been in the works at the FMC. He's reported on that, but we haven't seen a standalone there. So I'm still waiting and watching for that. The piece about does your other cargo go into delinquency if you don't pay on a current invoice, right? Like if you want to file a dispute against a current invoice, what does that mean? It's not clear what happens there, because I mean, in theory, if you say, okay, well, if there's a dispute filed, then you can't put any of the other cargo in delinquency, right? It can be tough because then potentially every shipper would be filing a dispute on every invoice and then not having to pay for a while because they're disputing, right? I mean, you're potentially pushing out any payments by 30 days. But then again, if you were to not have that in place, then you potentially get to the situation where it's easier to get a waiver of an invoice than it is to get refunded on an invoice, right? I mean, it's easier if you don't pay and then they waive it than to try to get your money back. And so that's what the shippers are kind of finding is that, well, if we don't pay it, then our cargo gets locked up kind of under this delinquency because we haven't paid an invoice, even though it's in dispute. But then on the other hand, if we do pay it and we're ultimately proved to be right under charge complaints or other process, then what if we can't get our stuff back? What if we can't get our money back, right? Like there's not really a continuation follow-up process for how fast that money has to be returned. And so that's been something that there's been some instances of that taking probably longer than people would expect or comfortable with. So I think the retaliatory piece is something that's still being ironed out. They had to start with the administrative easy stuff, right? And I think that's where they started. And even this unreasonable refusal to deal or negotiate was tricky. And I think there's a petition filed against that rule as well.
Yeah, go into that. What exactly does that?
Yeah. So, I mean, so same thing. This unreasonable refusal to deal or negotiate is a really interesting rule because it deals with.
This was one of the elements of OSRA 22 as well.
That's right. Yep, that's right. So it deals with kind of two parts of one of the statutes. So it's 41104 and it's A10 and A3. So A10 basically says a common carrier, either alone or in conjunction with any person, directly or indirectly, shall not. And 10 says unreasonably refuse to deal or negotiate, including with respect to vessel space accommodations provided by an ocean common carrier. So that's exactly what this rule was supposed to define. That was already the law. And then they also expanded it to include subsection 3, which was unreasonably refuse cargo space accommodations when available or resort to any other fair or unjustly discriminatory methods. And that's where they're kind of folding it in because that's where that unfair or just unjustly discriminatory methods is a requirement under the statute. But this rule is interesting. That was supposed to be buttoned up in 6 months after OSRA 22, but it just got released about 2 years later this summer in July. One thing that's particularly interesting, and I'm not sure how this is going to play out in the long term, is that they list non-binding examples of unreasonable conduct. And for both A10 and A3, so the refusal to provide cargo space accommodations and the refusal to deal and negotiate. But I mean, these are like operational level. Like some of the things that are non-binding examples are blank sailings with no advance notice or insufficient advance notice, vessel capacity limitations not justified otherwise by transportation factors, failing to alert or notify shippers of confirmed bookings, of any changes to the sailing that'll affect when their cargo arrives, unreliable vessel information. So initially the rule was kind of just on the systemic exclusion of exports. That's what this was trying to hit.
Right.
Was at the time they were saying, nope, we're not taking any exports. We're just going to try to go get that $20,000 imports
this was
rate.
The pandemic. So you were trying to race back to Asia to fill up the stuff that we were buying. Exports were being left at the dock. Exporters were lobbying Congress to make sure that their cargo was also going to get picked up by the carriers, even though it's far less lucrative than import cargo from Asia. Sorry.
That's right. Yeah. And the exporters that were, the carriers that were doing that are mostly gone, right? They were kind of pop-up carriers. Sure. And so that was a small term problem, but what Congress was trying to do was prevent that from happening, because we also don't want the extreme trade imbalance of the US, right? Where you want to still have exports flowing. We have some very important exports that need to get out. And so even though it wasn't as lucrative financially to export at the time.
Economy.
Yeah, exactly. We that was part of what Congress really was hitting on there. But I mean, those are operational. And the FMC is general competition, and they're looking at monopoly effects and behaviors, anti-competitive behaviors. And so talking about blank sailings with no advance notice, I mean, blank sailings are arguably, operationally driven. And what they're trying to get at is the extreme examples of like where blankings are used over excessively, right? And to the detriment of import or export with no advance notice. But where's the line, right? That's the piece, is like, where is the line from extreme that you want to have some sort of cover on to okay, well, was that just a repositioning of the vessel, or just a general schedule change based on weather, or was it something that was used to artificially change something? I mean, do you want the FMC there? And so that's why
Delineating intent on that kind of thing. Like,
exactly.
was it a cost savings thing on a one-off basis, or is
Mhm,
it part of some campaign to isolate the U.S. export industry? Right, like
exactly.
that's yeah.
Exactly, and vessel capacity limitations, right? I mean, it's just it feels very operational. And then for the refusal to deal and negotiate, they go as to so far as to say quoting rates that are so far above current market rates. Okay, the extreme example is probably going to be easy to see, but if we had talked about in 2015 $20,000 Asia to West Coast rates, that would have been so far above current
Yeah,
market rates.
no one would have believed it.
Right, but then that became the reality because at the time, right, it was $1,200 or something in
Right,
2015. So,
right.
so where is they're not I mean, they have a ton of economists on staff, right? So I mean, they certainly are involved in the numbers of it all, and that's what the competition authority. But on the other hand, I mean, they're not regulating rates specifically. They're regulating the reasonableness of activities that happen in the competitive global ocean shipping world. So it just feels like it's moving into some more specific areas, and that's really what the petition is about is and we don't have a lot of information on the specific issues. It'll be probably another few months before we get that, but
Well,
that's what I anticipate is that they are picking at you don't do rates.
yeah,
Like you
yeah.
don't do operation. Like what statute from Congress gives you the authority to be in this world?
Well, we'll have to have you back when there's more clarity on that. So, I cannot believe how fast this all went. We have like 2 minutes left. And I have two questions. I don't know if you're going to be able to answer this in a minute, but the Chevron case that
Mhm.
was before Supreme Court, which essentially, I'm going to summarize it here. I'm not a lawyer, so don't sue me, not you, but the audience. Um, Essentially sort of stripped some enforcement power from U.S. agencies that were not elected but were appointed. Is that kind of like a give
So so
you can answer that and then say, like, is it having any impact on FMC's ability to
yep.
enforce rulemaking? I think
Perfect.
that's
So, and first, before we go anywhere near an actual case, I should say all of our discussion today is not legal
not
advice
legal
directly
advice.
related to your matter, right? If you need an attorney, contact an attorney. This is not it. This is not an attorney-client relationship. So, what's happening here? So, Chevron was a case from 1984, actually. So, Chevron versus Natural Resources Defense Council, NRDC. That was the case that gave agencies deference. So, there was a two-part test that basically said, is the statute clear from Congress? And if it's not, then the court was supposed to review if the agency kind of reasonably interpreted what the statute said. Now what's happened, this is the Loper Bright versus Raimondo, the same Gina Raimondo, the former governor of Rhode Island, now the Secretary of Commerce.
Yeah.
Loper Bright versus Raimondo, where it says, look, the court shouldn't be deferring to the agency automatically. It should remain an independent review at the court. And so what that means is that this automatic Chevron deference, and it was never fully automatic, but it was becoming very commonplace, was, well, the agencies are the experts, they should be the ones who know. So that was kind of what happened, is that now it remains with the court system, as the Supreme Court basically says, as everything intended, the Constitution intended that to be. So this will have some effect on the FMC, particularly with these petitions that have been filed, because this happened after the petition for the D&D rule, where previously I might have said, look, there was some final rule fixing that happened that the FMC did. Perhaps this petition now becomes moot because the Chevron deference piece has been overturned, and now the court has to review everything with a little bit more of a watchful eye. I think it gave new life to that petition, where the court will actually be, okay, this is a little bit outside of our lane, right? Like, we're not global ocean shipping experts. We want to know exactly what's happening here. I think it might have just made that petition process a little bit longer.
Got it.
We'll see.
Okay. Yeah. The interviewer should not ask a question like, explain the significance of
That's all right. It was
with 1 minute left in the show, but I did want to address it. Okay. Last question. My favorite question for every guest: who's your favorite band or musician? And you have to tell me why.
genre yacht rock, obvious reasons.
Yeah.
Actual artist though, John Mayer. I am just addicted to his show on Sirius XM,
So am I.
the
I
John
love
Mayer
that. My
show.
son always complains that when he gets in the car after I've been alone, it's always on that station. He's a incredibly talented guy. I think he gets sort of typecast as like, mom rock or, just kind of
Yeah.
like lightweight stuff, but he's an insane guitarist, actually.
Yeah,
Like
that's
a
right. Well, and
ridiculous guitarist. So
my friend had met him before he made it big, way, way, way back when. So I kind of was following him in the early 2000s, watching him come up. And then he just, has exploded, especially as he went with Grateful Dead and all that.
yeah.
Also Aerosmith. But that's an easy band to pinpoint as well.
No, these are good. These are good. We'll add them to the playlist. Lauren, thank you so much. We had far too much to cover. You did an amazing job of going through a lot of deep, complex subjects. Thank you so much. What's best way to reach out to you? We've been running your Maritime Professor and Squall Strategies URLs. Is there anywhere else that's a good place to reach you?
Yeah, both those websites, .com at the end of both of those. LinkedIn, I'm very active on. Follow me there. Or listen to me on my podcast Fridays at 1 p.m. It's called By Land and By Sea, an attorney breaking down the week in supply chain, where we kind of have conversations like this in just real people terms.
Yes, I definitely recommend tuning into that show on Fridays as well. It's a great resource. Thank you, Lauren. It was great to see you.
Eric.
Have a great weekend. Okay.
You too.
Talk soon. Okay. All right. We're late. The legal stuff is complicated. I will tell you that much. My mom was an attorney. I very much decided early on I did not want to be an attorney myself because it's too complicated for my Luddite brain. All right. It's that time. Dad joke of the week. I know Halloween was yesterday. It would have been better if I did this before Halloween, but we're all still there's still candy on everybody's counter right now. So what's a witch's favorite subject in school? This one ought to be kind of simple if you think about it. Spelling, obviously. There you go. Good holiday themed dad joke to take us home. Thank you, Lauren. Fantastic conversation. Definitely reach out to her if you have any questions about the legal side of the world of maritime. And thank you to Nicole, world's best show producer. Thank you to the Let's Talk Supply Chain team for making this so easy for me. But most of all, thank you to everyone who tuned in. Anthony, Suleiman, Morteza, Tariq, thank you for dropping comments in the comments as well. I really appreciate you attending this week. And I will see you in a couple weeks with another great episode of LogTech Live. And hopefully my voice will be completely back by then. Have a great weekend, everyone. See you soon. Bye.